Franke de la Fuente, we usually recommend our clients that have bought a property here in Spain or in any other capacity has any assets here in Spain to write a Spanish will that covers their assets only here in Spain. Even though it is that the Spanish law validates any other will that you might have written in your home country, this is perfectly valid, but we still recommend that you write a Spanish will. This is mainly to make the inheritance process easier here in Spain. If you have a foreign will, you would need to legalize it to prove that it's correct according to your law, and then you would also have to translate it into Spanish with an official translator. And these are, of course, steps that costs money in the other end. Even if you pay for an extra will here, you would not save anything, since you have to do those other steps once you have to shift the assets in the inheritance process. So this takes more time, makes the process longer and more costly. And then you have the other aspect, that is that when you're working with a foreign will, you would need to make sure that it's translated in a way that truly shows the correct will of the testator. If you have written a will here in Spain in Spanish with a Spanish notary, you are there to ensure that it's written in a way that will correctly reflect your wishes, and the assets will therefore be split in the way that you intend them to. There's always a risk when you're translating a foreign document into another language by somebody who is not in direct contact with the one who wrote the initial document. There's always then the risk that something might not turn out the way that the testator wished for it to do. Another aspect is that in certain jurisdictions you might have very different demands from the law on how to write the will and how you keep this. In Sweden, for example, a will is written simply by the testator together with two independent witnesses who have to also sign the document and guarantee that the testator is writing this will and that they are in full mental health, etc. But there is no registry like in Spain where you can register the will and keep it. There are, of course, different services in Sweden where you can store your will, a law firm or certain companies that provide the service, but there is nothing regulated about it. And so any will might be in the testator's home as well, or in a safe somewhere that it might not be accessed until after the assets are already distributed between the heirs, or it might be lost. There are several different complications that might arise. While with a Spanish will, you have a central registry in Madrid where every will has to be registered. You have to write the will in front of a notary public here in Spain, and the notary then mandatorily sends this will to be registered in the registry. Once you are in the inheritance process, is then a mandatory step for whoever is making the process, a lawyer, etc., to make a petition to the registry to ask whether or not the deceased party has issued a will here. You will get a certificate in response that shows whether or not there exists a will, and in case a will exists, you need to order a copy of this. This ensures that the will is always taken into consideration when splitting the assets. Another part of writing a will is also that you have the possibility of choosing the law that is governing your inheritance. So if you're a Swedish citizen that owns a property here in Spain, you write a Spanish will, you may choose to apply Swedish law to the inheritance. Not everybody knows this, but the law that applies to your inheritance is usually, according to the valid legislation in the European Union, it's whether or not where you have your domicile. So if you're a Swedish citizen and you live in Sweden, Swedish law will apply to all your assets. But if you later in life choose to move permanently down to Spain, suddenly it would be Spanish law applying to your inheritance if you don't have a will. And this can be something that might come as a shock for certain people that don't count on this when they make the move. But if you have a will, you will always be guaranteed that the law that you choose will be applied no matter where you move in the world thereafter. One important thing to note regarding wills is that it's called the last will, and that's also how legally it applies. So only the last will issued is valid. When a client has already a foreign will, we issue usually the Spanish will, saying that the Spanish will only applies to the Spanish property, and therefore the foreign will still be valid for all property except for the Spanish one. This is important to keep in mind, because if the client then would at any point update the will in their home country, it's important to then write in that will that it's valid for every part of their property except the ones in Spain, which is governed by a separate will over there. If they do not, then and write a will that universally covers all their property, then the Spanish will automatically be revoked and therefore not apply. So it's important to keep this in mind, and then for the client to mention this to their lawyer in their home country in case they would make an update to their will over there. Regarding the inheritance process itself here in Spain, there are two different scenarios when we're talking about international clients. You will have the residents and the non-residents. In case of a resident, the death certificate will be issued here in Spain, in the municipality where the deceased was last having their domicile. And for a non-resident, you would have the death certificate issued in their home country, and thereafter legalized and translated into Spanish to be used here in Spain. For a resident, all your assets are included in the inheritance here, while for a non-resident, you only include the Spanish assets in the inheritance here, and the rest of your assets will be divided according to the process in your home country. The process itself here is pretty straightforward. The lawyer in charge collects the death certificate and all other important information about any properties and assets here, bank accounts, properties, cars, boats, etc., whatever the client might have in their possession. You recompile all the assets that are to be divided. You apply for the certificate in the registry of wills in Madrid to see if there's any Spanish will, and if there are foreign wills, you need them translated and legalized. And if there are no wills, then you have to go to the law to see how the inheritance is to be divided. After all of this is done, you go to the notary to emit an acta de herencia, an inheritance act, in front of the notary, and this is the official document with which you can then register the ownership of all the assets in the names of the heirs. If you have a property, you can go to the land registry with this act to register the property in their names. If you have bank accounts, you can close them down and transfer the funds, etc. And it's important to distinguish this from, for example, in the Swedish law, where the estate itself is a legal entity. In that case, you can sell houses and cars, other assets already before, and then just shift the money that comes from this if the heirs so wishes. While here in Spain, it's impossible to do, and you need to first shift the property into the name of the heirs, and then they can sell it if they so wish. So even though, as previously mentioned, you may choose the law that governs your inheritance, this only applies to the law that for the inheritance itself, for how to distribute it between the heirs. This does not apply to other national rules, like for example the tax law. Every country have different rules regarding this, and in Spain, for example, in comparison to Sweden, there exists a tax law here for inheritance and donation tax. And this is also different in each autonomous region. So Andalusia has their own inheritance tax compared to other regions, Madrid, Extremadura, and so on. Here in Andalusia, you have a significant amount of money that is tax-free, and this applies to each heir individually. But regardless of this, even if you pay any inheritance tax or not, it's mandatory for each heir to present a declaration of inheritance tax. This needs to be done to the tax office in Madrid. So this is a mandatory part of the inheritance process, no matter if you actually have to pay any tax or not for the inheritance that you receive. And as the tax rates are continuously updated across the board, we always recommend you to hire a lawyer to help you with this process, to get everything right. And we here at Franke de la Fuente have many years of experience with inheritance processes, writing wills and declaring taxes, and we are happy to help.